Hi, everyone. I thought I'd discuss with you today some major developments in litigation against Trump administration executive policies and in the last 24 to 48 hours, and also touch on a remarkable moment in the U.S. Supreme Court oral argument on birthright citizenship, in which the Solicitor General appeared to suggest that there are instances in which the Justice Department believes it does not need to abide by a circuit court opinion, as remarkable as that is. And I'll talk about what I think the potential scope or limitations are of what he's saying and how dangerous it might be. So, first, there are two areas I thought to discuss in the last 24, 48 hours. One is immigration policy, the Alien Enemies Act, and the other is First Amendment rights, especially instances in which two judges have rendered opinions in the last 24, 48 hours that I think show us the enormous threat of some of the actions by the administration on trying to clamp down on the expression of First Amendment rights, but judges pushing back. So let's first talk about one of the most unusual cases that came out in the last 24, 48 hours in the Western District of Pennsylvania. Stephanie Haynes, a Trump appointee, is the first judge in a district court to actually to hold that the Trump administration is properly using the Alien Enemies Act. All the other judges have said that it's not a proper invocation for one reason or another. We're not under an invasion or all things like that. Instead, she does something really remarkable. She says she's giving substantial deference, but I think it's complete deference to the president's mere assertion in the proclamation that the Tren de Aragua, TDA gang from Venezuela, is acting at the direction of the Maduro regime. She says it's substantial deference, but just listen to the actual words. The opinion says the court will accept as true President Trump's conclusion via the proclamation that TDA is acting at the direction, clandestine or otherwise, of the Maduro regime in Venezuela, end quote. That's an abdication. That's not deference. That's an abdication of the judicial role. Just the fact that the president asserted that fact, she's not going to look behind it or scrutinize it, which you think a court does. That's what a court does. It reviews factual allegations and the like. This is coming especially after we now know from a declassified intelligence community memorandum that the U.S. intelligence community does not believe that TDA is acting at the direction of the Maduro regime. In fact, the memorandum says it would be illogical, given that the level of cooperation that would have to exist between two factions that are fighting each other, in fact, and that the U.S. intelligence community would know and have information if they were acting in coordination or at the direction of. And another part of her opinion is to say that she defines very much down what it means to have engaged in a war, invasion, or predatory incursion. She takes the word predatory incursion. She says, oh, well, this terrorist group is acting, the so-called terrorist group is acting in a form of a predatory incursion. She defines predatory separate from incursion. I think if you put the two together, it's a higher threshold, and she defines it separate from a foreign government. So if you talk about a predatory incursion from a foreign government, the legal historians tell us, and other judges tell us, that means something like an armed attack, especially 1798 with the Alien Enemies Act when it was passed. But she says instead, no, it just needs to be a coherent group that's engaged in destructive actions within the country. And to me, not only will that potentially be overturned on appeal, but if we're talking about something like that, why would you give the executive branch such enormous deference? The deference, if there is such deference to be given, significant deference, let's say, it's usually in context of war or invasion, not predatory incursion defined to its lowest limit. I think those are some of the serious, serious problems. And there's even ways in which she cites prior Supreme Court precedent that looks like I'm not sure what the basis is for her thinking, because she cites one case, but she should have cited another, and she doesn't actually cite it for standing for a proposition, just says almost like, oh, and there's also this case out there. So I don't think this is a very strong judicial opinion. At the same time, I should also note that she does say that though the Alien Enemies Act is properly invoked, the Trump administration is violating due process because they're not giving people fair notice. They're suggesting that they only need to give 12 or 24 hours notice to individuals, and it's not even clear what the notice is. Like, is it just notice that you're going to be deported under the Alien Enemies Act, or is it also notice that to give the person an understanding that they can bring a habeas case? So she says it has to be 3 weeks notice, and to make good on the Supreme Court ruling, which was to say that in Alien Enemies Act cases, there must not just be notice that it must be noticed so that people can effectively exercise their habeas rights. At the same time, as her decision, same day in the Western District of Texas, which is usually an area of the country that would be more favorable to the Trump administration, a judge ruled against the administration on the Alien Enemies Act case. Judge Briones said that there's a sufficient likelihood that the plaintiffs before him would succeed on the merits, such that he issued a temporary restraining order. And when he said on the merits, he said that their argument seems to be valid, according to him, that the proclamation would violate, in his terms, the Alien Enemies Act. Doesn't fit the Alien Enemies Act, it actually violates it. Judge Briones had also, in late August, issued a order for the immediate release of two individuals who were alleged to be TDA members, and he said that the allegations were baseless, and he referred to a prior court hearing in which a judge had said that the government affidavit that they had entered to allege that these two individuals were members of TDA or associates of TDA was an affidavit that if it were, quote, accompanying a criminal arrest warrant, the court would throw you out of its chambers, end quote. In other words, it is so ludicrous and so weak of an argument, the evidence that they were presenting. And I do think that gives us an indication of what can happen when people do have the ability to exercise their right to get to a court hearing. Now, in some cases, they will be TDA members, but in a bunch of other cases, we're talking about people who are improperly accused of being TDA, not just being deported from the country, but are in fact being sent to places like the CCUT torture chamber in El Salvador. First Amendment issues. There were two very significant cases. In each instance, the judge invalidating administration action. One case is the case of another habeas case, Mr. Badar Khan Suri. He is a student studying at Georgetown, a doctoral associate at Georgetown University, an Indian national, and the judge said that the only basis given for his detention and subject to deportation is his exercise of First Amendment rights, that the only evidence that was being presented was that he had basically protested against the Gaza war, and she said that cannot stand. So that's one indication of what's going on behind the scenes of these cases and the government's allegations, but courts pushing back. Another case in the last 24 hours is the American Bar Association case. In that instance, the judge ordered a preliminary injunction in which the allegations or the court record now that the judge recites in the first 2 pages of the opinion are really startling. It's just amazing that I even am able to say these words as to what occurred, according to the judge. The judge says that the second in command at the Justice Department, Mr. Todd Blanche, sent out a memorandum to the Justice Department that said employees should not attend ABA events, American Bar Association events. Why? Because the American Bar Association is filing cases against the administration, representing individuals to try to vindicate their rights. And what does he do following that? He rescinds a grant to the American Bar Association to do what? To fight domestic violence and sexual violence. And the court says, look, there are a lot of arguments that the ABA is raising against this action. I'm just going to decide this on First Amendment grounds, and this is retaliation for the exercise of First Amendment rights. We don't need to go anywhere else on that. And the court also says something else that's really astonishing, that the government didn't even really contest it, couldn't even really contest it, that it was retaliation, that this was a First Amendment issue, that what the government tried to argue instead was just that the court didn't have jurisdiction to decide. And the judge says, I have jurisdiction. It's a First Amendment claim. So that's just giving you a sense of how close to and off the cliff, in a certain sense, we already have gone on the First Amendment issues, but judges bringing us back. Lastly, I want you to listen to the Solicitor General speaking to Justice Amy Coney Barrett in the oral argument before the Supreme Court on birthright citizenship. He had already answered this question in part to Justice Kagan, who seemed to be in disbelief. But listen for when Justice Amy Coney Barrett says the word, really? Because she's just astonished at what he's saying to her. Here's the tape.
You resisted Justice Kagan when she asked you whether the government would obey within the Second Circuit a precedent. I'm distinguishing between opinions and judgments here. Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents. But there are circumstances when it is not a categorical practice. It is, and that is not
This
a new
administration's
policy.
practice or the longstanding practice of the federal government? And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding
Really?
policy of the Department of Justice. Yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. And some examples might be a situation where we're litigating to try and get that circuit precedent overruled and so forth.
Well, okay, so I'm not talking about a situation in which, you know, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this week, the Second Circuit holds that the executive order is unconstitutional, and then what do you do the next day or the next week?
Generally, we follow those.
So you're still saying generally?
Yes.
And you still think that it's generally the policy, longstanding policy of the federal government to take that approach?
That is my understanding.
Okay, so, but it sounds to me like you accept a Cooper versus Aaron kind of situation for the Supreme Court, but not for, say, the Second Circuit. Like where you would respect the opinions and the judgments of the Supreme Court, and you're saying you would respect the judgment, but not necessarily the opinion of a lower court.
And again, I think in the vast majority of instances, our practice has been to respect the opinion as well, in the circuits as well, but my understanding is that has not been a categorical practice in the way respect for the precedents and the judgments of the Supreme Court has been.
So you're not hedging at all with respect to the precedent of this court?
That is correct. I believe the quotation from our application directly addresses that, and we stand by that completely.
Okay.
So what is the Solicitor General suggesting? It sounds like he's saying, here's the hypothetical. Ms. Smith brings a case in the Second Circuit against an executive action. The Second Circuit says it is facially invalid, totally unconstitutional. This executive action can never pass. That's our opinion. And our judgment is in favor of the plaintiff. It seems like the Solicitor General is saying, okay, we're bound by the judgment as to the plaintiff, but we're not necessarily bound by the opinion. And we can continue to use that executive action in the Second Circuit to other residents in the Second Circuit, New York and beyond. And because they didn't say we couldn't do it to them. There's no judgment with respect to them. So we'll continue, even though that now is in defiance of what is the rule of the Second Circuit. That is why Justice Amy Coney Barrett and Justice Kagan were saying, what on earth are you claiming here before the Supreme Court? And I do wish that she or one of the other justices would have followed up by saying, give us an example. What's an example when you say this is actually a settled practice of the Justice Department, that it can, in very exceptional cases, do this? Now, that said, there was a debate among scholars in the 1980s, 1990s, in which there's this notion of intra-circuit, within circuit acquiescence. A couple of my colleagues at NYU Law School actually advocated this idea, but it was particular to administrative agencies, and administrative agencies given a role to try to create nationally uniform standards. If that's what Mr. Sawyer is thinking about, the Solicitor General, he should have said so, because that's more limited. If, in fact, what he and the Justice Department are doing is try to even expand that further, I think there's going to be a lot of blowback to that. And I think it's incumbent upon them even to clarify that beyond the oral argument now, just publicly, because the nation is watching, the world is watching, when he says something so dangerous as the idea that they do not need to abide by a court opinion. And when this idea of intra-circuit acquiescence came up in the Ninth Circuit, in the Second Circuit in the 1990s, there was significant blowback. There's a congressional research report on this pretty recently, and I'll put that in the show notes. So that alone would be controversial. And I think that the Supreme Court would push back hard, as you can see from Justice Amy Coney Barrett, conservative jurist, and Justice Kagan, liberal jurist or non-conservative in a sense, that they would both find this so anathema to the rule of law in the way in which the Solicitor General raised this prospect. So stay tuned. We'll see if what the Justice Department is thinking or what they'll be doing. There'll be a lot of close watchers, and at least now many judges across the country will be on alert to see what Mr. Sawyer meant or may have meant. If you enjoy this discussion, please subscribe to the channel. Please like the video, and please engage in comments. I always enjoy reading comments and getting feedback, and I'll put all of the material I've discussed in the show notes. Also, all of the cases are referenced in the Just Security Litigation Tracker. I'll put a link to that as well. We try to summarize the cases and then just give you all of the documents so you can do the research for yourself as well and the reading for yourself. Thanks for joining me. Until next time.